All right. It's 24 TR 8100 and 24 CT 786, State of Wisconsin versus Schultz. I'll take appearances, please.
Jeff Kroll for the state.
And good afternoon, Your Honor. Megan Schultz appears with counsel. Frank J. Parise, also present in court, are her parents.
Good afternoon. Stay compliant with victim rights.
We are, Your Honor. It's a
All right.
victim impact statement entered court.
Thank you. All right, this is here again for a plea and sentencing. Are we ready to proceed this time?
Judge, yes, I would indicate that pursuant to the agreement, Ms. Schultz will be pleading guilty to the single count in the complaint. At the time of sentencing, the state will be making no specific recommendation as applies to the jail time. However, they will be recommending, and I don't have it in front of me, but it's in the plea form. I think it's $1,000-something fine, and
It's $1,019.50. That
Yes.
sound right?
yes.
All right.
And then the revocation period, and then also dismissing the TR.
Is that your understanding, Ms. Schultz?
Yes.
All right. I know we did this before, but I have a series of questions to ask you. If at any time you can't understand me, have questions of your own, or can't hear me, please interrupt me and let me know, all right?
Okay.
All right, thank you. You're 36 years old and have more than 12 years of schooling, is that correct?
Yes.
Fair to say you read and write the English language pretty well?
Yes.
Did you review the plea questionnaire waiver of rights with your attorney and fully understand it?
Yes.
Is the information in it true and accurate to the best of your knowledge?
Yes.
Did you also go over the elements for operating while intoxicated with minors in the vehicle?
Yes.
All right. Plea questionnaire indicates you wish to change your plea to that of guilty to that charge. Is that your understanding?
Yes.
Do you understand that if the court accepts a guilty plea from you, you will be found guilty?
Yes.
Do you understand that a guilty plea waives all non-jurisdictional defects and defenses, including constitutional claims?
Yes.
Do you understand you're giving up your right to a trial in this matter?
Yes.
Do you understand that by entering a plea here today, you're waiving your right to remain silent and to testifying on your own behalf?
Yes.
Do you understand that the state has the burden of proving each and every element of the charges in the complaint?
Yes.
Do you understand that that burden is beyond a reasonable doubt, which is the highest burden in our court system?
Yes.
Do you understand the elements that the state must prove are that you drove or operated a motor vehicle on a highway, and that you were under the influence of an intoxicant at the time that you drove or operated that vehicle, and
Yes.
that there was minor passengers under the age of 16 in that vehicle?
Yes.
All right. And while there may or may not be a recommendation promised here by the state, this court is not bound to follow any recommendation made by any party and can sentence you up to the maximum penalties in the complaint. Do you understand that?
Yes.
Do you understand the penalties are a fine of $350 to $1,100 and imprisonment of not less than 5 days nor more than 6 months?
Yes.
Has anyone made any threats or forced you to enter a plea here today?
No.
Has anyone made any promises to you in order to get you to change your plea here today other than the agreement as stated on the record?
No.
Has anyone, are you entering a plea change freely, voluntarily, and knowingly?
Yes.
Have you used any drugs or alcohol in the last 24 hours?
No.
Do you understand, did you review the complaint in this case?
Yes.
Do you understand what it alleges you did?
Yes.
Do you agree that the facts contained in the complaint are accurate and may be used by this court as a basis of fact to accept your plea here today?
Yes.
Do you understand that if you are not a citizen of the United States, you are advised that a plea of guilty for the offense for which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law?
Yes.
Are you satisfied with the legal representation that your attorney has provided you in this matter?
Yes.
Has he answered all your questions?
Yes.
Are you at all confused about what you intend to do here today before this court?
No.
Attorney Parise, have you had sufficient time to go over the plea questionnaire and waiver of rights with your client?
Yes, Judge.
Have you gone over the discovery, the allegations in the petition, and the potential defenses available to your client?
I have.
Are you satisfied that your client understands the charges against her, the elements thereof, and the possible consequences of an adjudication of guilt?
Yes.
Have you gone over her constitutional rights and the effect of waiving those rights here today?
Yes.
Are you satisfied and of the opinion that your client is freely, knowingly, intelligently, and voluntarily entering into a change of plea?
Yes.
And do you believe the facts from the criminal complaint set forth an ample factual basis for this court to accept a plea from your client to the charge of OWI first offense with minor in the vehicle?
Yes.
All right. Ms. Schultz, the complaint alleges in count 1 that on November 17th, 2024, in the city of Kenosha, Kenosha County, Wisconsin, you did operate a motor vehicle while under the influence of an intoxicant and committed this offense with minor children and under the age of 16 as passengers in the vehicle, contrary to Wisconsin state law. How do you plead?
Guilty.
Thank you. All right. I've reviewed the contents of the court file and find there is a factual basis for the plea. Court does accept the plea from the defendant, finds her guilty, and orders that a judgment of conviction be entered consistent with count 1 in the complaint. Court is satisfied the defendant has freely, knowingly, intelligently, and voluntarily entered into their plea of guilty, and the court will accept that plea. As to sentencing, state.
Thank you, Your Honor. Per the recommendation and the agreement of the parties, state's recommending jail but staying silent on the amount and defer to the court's discretion. However, we will be requesting a 12-month IID order, 12-month driver's license revocation, and a $1,019.50 fine. There's just a few things that the state would want the court to keep in mind here in proceeding to sentencing today. I will, of course, note the defendant has no prior record. I don't think there's any allegations thereof of that. And I know that the victim in this case had filed a victim impact statement with the court talking about restitution that had not been paid. Since that has been filed, I understand that the defendant has made payments for restitution and provided that in its entirety, just so the court was aware of that. Otherwise, I would just like to have the court review and understand some of the allegations in the probable cause statement, including that the defendant tipped over her vehicle while driving intoxicated. VAC came back in this case for an amount of .218, and she had been driving the vehicle with her 2 minor children in the car, including a 6-year-old and an 8-year-old, before crashing into a parked car on the side of the road. I understand that the children were checked out by Kenosha Fire Department and they were deemed fine on scene. No injuries were suffered. However, driving with a .218 blood alcohol content with 2 children in the car and then the crash resulting in the vehicle tipping over, it is miraculous that nobody actually was hurt. And I think the victim impact statement is accurate to note that it was only by grace of God that this didn't turn out any worse than it did. It could have been a car coming from oncoming traffic, but in this case, the defendant did strike a parked car. Otherwise, I would just note that while the defendant was forthright about the number of drinks that she had consumed when talking to officers, I would note that eventually the defendant stopped answering questions and did refuse a PBT understand at the time. Otherwise, I have nothing further to add and defer to the court. Thank you.
All right, Attorney Parise.
Judge, thank you. I would note that Ms. Olster is age 36. She is a lifelong resident of Kenosha. Her parents are present, and honestly, she comes from great stock in that sense. I've known her parents probably since high school, maybe even longer, and they are, as the axiom is, pillars of the community. Ms. Olster herself does have and continues to have a career in figure skating. She coaches young people and is very highly thought of. As you can read from the letters, they think very highly of her, are not making excuses for her behavior here, but understand and believe that she is committed to better herself and to be accountable for her actions, which also explains her guilty plea here today. I would note, Judge, she has absolutely no prior incidences of anything, including alcohol-related or any other incidences of any kind in her 36 years. I would note, too, Judge, that the damages that were talked about, we actually were requested very early on. The police report was incorrect when it said she had no insurance. She was fully insured. And in fact, when we were notified that there might be a problem from the DA's office, we immediately provided all of the insurance information so that the complaining witnesses could be made whole. I would note that she has been bond compliant now for almost a year and has not only been bond compliant, but also completed treatment and counseling. One of the things that struck me, knowing her and knowing her career and her history and how other people think about her, what was happening in your life? I mean, why are we here? And the only explanation, and it wasn't even an excuse, is I let alcohol get the best of me. I just recently was going through a divorce. And she'd been a couple of months removed from that divorce, and apparently she let the stresses of life get the best of her. Again, she's never made that as an excuse. It was just my prompting asking that question. It was important to know, and I think it's an explanation at least, but not an excuse. With that said, Judge, certainly she would like to keep her employment. We are asking the court to consider that. Also consider Huber and ELM would be appropriate here. She does provide for her children. I would note that we are asking for a report date in this case of October 25th, which isn't this Saturday, but would be the following Saturday. That does fit in with work scheduling as far as her being able to organize things in that regard. As relates to jail credit, Judge, she did spend 1 day in jail, so we're asking for that credit as well. Thank you.
All right, thank you. Ms. Schultz, you certainly have a right to make a statement to this court before a sentence is handed down. Is there anything you'd like to tell me?
I just want to say that I'm really sorry for this poor decision that I made. I definitely wasn't thinking clearly, and I'm really sorry for everybody in my life that it's affected, the people that I love the most. And this has really helped me actually grow as a person, and I've changed a lot in the last 11 months. And I am really grateful for that. But I'm just gonna take what I've learned from this and continue to show up and be the best mom I can be for my kids, because they're the most important to me and I love them so much. So.
Thank you. All right, there are a number of factors this court must consider at the time of sentencing, and that includes the gravity of the offense, the character of the offender, and the need to protect the public. Certainly all those factors overlap one another here today for you, ma'am, as they do for everyone who comes before this court. Also, the court is mandated to impose the least restrictive sentence necessary in order to achieve the goals of sentencing. Here, rehabilitation is an important component, as well as punishment and accountability for decisions made and protection of the community. I have read the character letters. I have read the victim statements. I do take into consideration that you finished your programming with WCS. I do find it's a first offense, but I find it particularly egregious as you had 2 children, ages 6 and 8, in the vehicle. The vehicle flipped. The vehicle hit 2 legally parked cars. You were actively drinking and driving. You had a pink water bottle filled with alcohol. The blood alcohol content was 0.218. I'm amazed no one was injured. I'm amazed no one else was hurt. I'm amazed no other charges were brought, to be quite honest with you. I think you probably recognize, and I hope you recognize, you have a drinking problem, and alcohol is probably not the best choice for you in the future. You clearly make terrible choices when you drink. And 2 of the most precious people in your life were in that vehicle. And you're supposed to protect them. And you drank and drove. All right. As to sentencing, I'll allow the motion of the state with respect to dismissing the TR. As to your sentence, it's a 12-month driver's license revocation, a 12-month IID device, a fine of $1,019.50. I'm going to authorize 100 days in the Kenosha County Jail, credit for 1 day previously served. I will grant Huber after 7 days have been served. I will grant the report date of October 25th at 8:30 a.m. You have to submit a DNA sample. Wait, this is a CT, right?
Yes.
Pay a DNA sample and submit a DNA surcharge unless previously done. Is there any money that was posted on this case previously? Let me look.
I don't see anything.
I don't see any bond
Signature
posted. No money previously posted. Does your client need more than 60 days to pay that fine, Attorney Parise?
No.
60 days to pay or a civil judgment will be had. You have the right to appeal the sentence and your attorney will go over those rights with you. Attorney Parise, anything else?
No, Judge.
State?
No, Your Honor.
Ms. Schultz, I wish you a sober good luck.
Thank you.
That'll conclude the hearing. Thank you.
Do you want to call into Josh?